compared to the impact of electoral bonds on the right to information, on an overall balance of the impact of the alternative means on the right to information and its ability to fulfill the purpose for contributions below 20,000 rupees, contributions through other means of electronic transfer is the least restrictive means. For contributions above 20,000 rupees, contributions through electoral trust is the least restrictive means. Thus, the infringement of the right to information is not proportionately justified for the purpose of curbing black money and electoral financing. Issue 3. Whether the infringement of the right to information of the voter is justified for the purpose of protecting donor privacies. Two issues arise for our consideration. A. Whether the fundamental right to informational privacy recognized by this court in Justice K.S. Puttaswamy, 9 judges, includes information about a citizen's political affiliation. B. If A above is answered in the affirmative, whether financial contribution to a political party is a facet of political affiliation. The fundamental right to informational privacy recognized in Justice K.S. Puttaswamy, 9 judges, includes information about a citizen's political affiliation for the following reasons. A. Forming political beliefs and opinion is the first stage of political expression. The freedom of political expression cannot be exercised freely in the absence of privacy of political affiliation. Information about a person's political belief can be used by the state at a political level to suppress dissent and at a personal level to discriminate by denying employment or subjecting them to trolls. The lack of privacy of political affiliation would also disproportionately affect those whose political views do not match the views of the mainstream. B. In the specific context of exercising electoral franchise, the lack of privacy of political affiliation would be catastrophic. Information about a person's political affiliation can be used to disenfranchise voters through voter surveillance. Voter databases which are developed through surveillance identify voting patterns of the electors and attempt to interfere with their opinions based on the information collected. For example, the data of online purchase histories, such as the books purchased, which would indicate the ideological leaning of the individual, clothing brands used, which would indicate the social class to which the individual belongs, or the news consumed or the newspaper subscribed, which would indicate political leanings or ideologies, can be used to draw on the relative political affiliation of people. This information about the political affiliation of individuals can then be used to influence their votes. C. At a systemic level, information about political affiliation could be used to engage in gerrymandering, the practice by which constituencies are delimited based on the electoral preference of the voters. Financial contributions to political parties are usually made for two reasons. First, they may constitute an expression of support to the political party, and second, the contribution may be based on a quid pro quo. The law as it currently stands permits contributions to political parties by both corporations and individuals. The huge political contributions made by corporations and companies should not be allowed to conceal the reason for financial contributions made by another section of the population, a student, a daily wage worker, an artist, or a teacher. When the law permits political contributions, and such contributions could be made as an expression of political support, which would indicate the political affiliation of a person, it is the duty of the Constitution to protect them. Not all political contributions are made with the intent of attempting to alter public policy. Contributions are also made to political parties which are not substantially represented. Contributions to such political parties are made purely with the intent of expressing support. It is true that contributions made as quid pro quo transactions are not an expression of political support. However, to not grant the umbrella of privacy to political contributions only because a portion of the contributions is made for other reasons would be impermissible. The Constitution does not turn a blind eye merely because of the possibilities of misuse. Thus, the right of informational privacy extends to financial contributions to political parties, which is a facet of political affiliation. We have applied the double proportionality standard to balance the conflicting rights of the right to information and the right to informational privacy. The Constitution does not establish a hierarchy between the right to information guaranteed under Article 19(1)(a) and the right to informational privacy to political affiliation traceable to Articles 19(1)(a), 19(1)(b), 19(1)(c), and Article 21. The Union of India submitted that Clause 7(4) of the Electoral Bond Scheme balances the right to information of the voter and the right to information privacy. We are of the opinion that Clause 7.4 of the Electoral Bond Scheme does not adequately balance the rights, but rather tilts the balance in favor of the right to informational privacy because A. The suitability prong of the proportionality standard is only partly fulfilled. The non-disclosure of information grants anonymity to the contributor, thereby protecting informational privacy. However, there is no nexus between the balancing measure adopted with the purpose of disclosure of information to the voter. According to Clause 7.4 of the Electoral Bond Scheme and the amendments, the information about contributions made through the Electoral Bond Scheme is exempted from the disclosure requirements. This information is never disclosed to the voter. The purpose of securing information about political funding cannot be fulfilled by absolute non-disclosure. B. We have proceeded to apply the subsequent prongs of the double proportionality standard, assuming that the suitability prong is satisfied. Section 29 capital C of the Representation of People Act, which states that information of contributions made below rupees 20,000 in a financial year need not be disclosed, is a lesser restrictive means to achieve both the right to information and the right to informational privacy. The underlying rationale of Section 29C1 is that contributions below the threshold do not have the ability to influence decisions, and the right to information of financial contributions does not extend to contributions which do not have the ability to influence decisions. Similarly, the right to privacy of political affiliation does not extend to contributions which may be made to influence policies. It only extends to contributions made as a genuine form of political support. It is quite possible that contributions beyond the threshold of rupees 20,000 could also be a form of political support and not necessarily a quid pro quo arrangement, and contributions below the threshold could influence electoral outcomes. However, the restriction on the right to information and informational privacy of such contributions is minimal when compared to the provision of blanket non-disclosure. Thus, this lesser restrictive alternative realizes the right to information of an informed voter and informational privacy to political affiliation in a real and substantial manner. The Union of India has been unable to establish that the measure employed in Clause 7.4 of the Electoral Bond Scheme is the least restrictive means to balance the rights of informational privacy to political contributions and the right to information of political contributions. Thus, the amendment to Section 13 capital A bracket B of the Income Tax Act, introduced by the Finance Act 2017, and the amendment to Section 29C1 of the Representation of People's Act are declared unconstitutional. The question is whether this court should only strike down the non-disclosure provision in the Electoral Bond Scheme, that is Clause 7.4. The anonymity of the contributor is intrinsic to the Electoral Bond Scheme. The Electoral Bond Scheme is not distinguishable from other modes of contributions through banking channels such as checks, transfer through the electronic clearing system, or direct debit if the anonymity component of the stream is struck down. Thus, the Electoral Bond Scheme 2018 will have to be struck down as unconstitutional. Issue 4. Whether the amendment to Section 182(3) of the Companies Act is unconstitutional. The amendment to Section 182(3) of the Companies Act, deleting the requirement of disclosing the particulars of contributions made to political parties, is unconstitutional for the following reasons. A. Section 182(3), as amended by the Finance Act 2017, mandates the disclosure of total contributions made by political parties. This requirement would ensure that the money which is contributed to political parties is accounted for. However, the deletion of the mandate of disclosing the particulars of contributions violates the right to information of the voter, since they would not possess information about the political party to which the contribution was made, which, as we have held above, is necessary to identify corruption and quid pro quo transactions in governance, information which is necessary for exercising an informed vote. B. Section 182(3) of the Companies Act and Section 29C of the Representation of People Act, as amended by the Finance Act, must be read together. Section 29C exempts political parties from disclosing information of contributions received through electoral bonds. However, Section 182(3) not only applies to contributions made through electoral bonds, but through all modes of transfers. In terms of the provisions of the Representation of People Act, if a company made contributions to political parties through check or electronic clearing system, the political party has to disclose the details in its report. Thus, the information about contributions by the company would be in the public domain. The only purpose of amending Section 182(3) was to bring the provision in tune with the amendment under the Representation of the People's Act, exempting the contributions through electoral bonds from disclosure requirements. The amendment to Section 182(3) of the Companies Act becomes otiose in terms of our holding that the electoral bond scheme and relevant amendments to the Representation of the People Act and the Income Tax Act mandating non-disclosure of particulars on political contributions through electoral bonds is unconstitutional.
உடனுக்குடன் செய்திகளை தெரிந்து கொள்ள சன் நியூஸ் பெல் ஐகானை கிளிக் பண்ணுங்க.